Good afternoon. My name is attorney Devin Shanley, and welcome to another edition of Lunch with a Lawyer uh, here at Peterson, Burke, and Cross. I hope your lunch is going well. Mine is going extremely well. Today's lunch is brought to you by the Stadium View. It's fall. That means it's time for football season, and you might be looking for something to do during a Packer game since you can't go for a little bit. So head down to the Stadium View, check out what they have to offer, uh, and if you're just looking for something not during game time, but still looking to head out, have a good time, go to the Stadium View as well. My lunch today is the fire roasted apple chicken sandwich. Uh, I would have never ordered this. So I need to bust out of my rut a little bit. And I told my paralegal, you just order something. So she ordered me this and tater tots. Again, something I wouldn't ever order. And it's been amazing. So I hope your lunch is going as well as mine. I have a delightful surprise. And when you do there, go check out the fire roasted apple chicken sandwich. I wouldn't have ordered it. Amazing. Very good fall type uh, dish. So thank you to the Stadium View. Thank you to all the folks there. As always, the service, the food, great, and I can't recommend that enough. The other disclaimers that I normally go through, I will go through again. Uh, the law that we have here, we are based out of the great state of Wisconsin. So if you are from the great state of Wisconsin, thank you for joining. Hello. Please feel free if you have further questions to give us a call. We'd be happy to help you out anywhere in the state, primarily in northeastern Wisconsin. If you are not in the state of Wisconsin, hello, thank you for joining us. If some of this stuff touches upon something you're concerned with, I recommend you talk to an attorney in your state who would be able to give you further advice. As always, none of the question and answers, if you're going to ask questions during the time or if you're going to ask questions later, none of these answers are going to be based on any particular set of facts. Instead, this is going to be general information on the law. None of this is intended to form an attorney-client relationship. If you do have specific questions about your sets of facts and you're like, Devin, this sounds like something I'm going through, that is great that you want to reach out. Please contact us either through our Facebook page, through our website, through phone call. If you can figure out how to get a messenger pigeon to us, that's fine too. However you need to reach out to us, please do. Our phone number is 920-831-0300. Schedule a appointment, an initial consultation with one of the attorneys here. We'll be happy to help you out and talk through your legal issues and give you a little bit of guidance to try and help you along your way. Today's topic is guardianships. Guardianships are an interesting area of law. In some ways, they deal with another area of law, power of attorney documents, that really didn't work because either they didn't have enough powers drafted to them, or more often, somebody just didn't get them done. But really, what the guardianship is, it's dealing with a situation where you have an individual who cannot act, but you still need something done. A person can't make their own medical decisions, but they still need that surgery. They can't manage their money, but the cable bill still needs to be paid, or rent still needs to be paid. Who is authorized to do that? And the guardianship becomes an avenue to allow the courts to appoint someone to step into their place, but also, and sometimes, make sure that they cannot act any further. So it's not just a giving powers to an individual, but stripping away powers as well. There are two basic sort of guardianships in the state of Wisconsin. The first is called a guardian of the person. The second is called a guardian of the estate. A guardian of the person is someone who is going to make decisions regarding, well, personal decisions, primarily decisions around medical decisions. But that can also be decisions for consenting to marriage, or decisions to participate in study, or consenting to sterilization. Decisions like this that are really going to go to the intrinsic personal nature of the person themselves. A guardian of the estate is for someone who is going just to manage somebody's financial decisions, their property, their holdings. Are they going to be able to buy that house? Are they going to sell items? Things of that nature. With both of these, there are a couple different abilities or different grounds to have someone appointed for this, but the most common is through something called incompetency. Incompetency is when the individual cannot make the decision for themselves, typically due to some sort of illness, developmental delay, something along those natures, although it could be something a little bit more robust depending upon the facts of the case. As you can imagine, in a free country, we don't want to have people just walking around and say, you can't do this anymore, and then suddenly you get all your rights stripped away. There's a court process to this. What you need to do is you would need to file a petition with the court. You would need to serve notice, not just to the individual and say, hey, I think you're incompetent. But it's also going to be to other interested parties. Those interested parties might be family members, heirs to the individual, so social security agencies, nonprofits that are working with the individual, the county themselves. If there's a guardian ad litem appointed, the guardian ad litem as well. Once you have that going, the individual also has rights. The individual would have the right to counsel. They would have the right to an attorney. And this would be something similar to when we talk about criminal cases. When we have criminal cases, you have the right to an attorney. Here, if we're going to be taking away your rights, you again have the right to an attorney, and in this state, you would be able to have a public defender appointed to you as well. The person would also have something called a guardian ad litem appointed for them. Now, a guardian ad litem, you might have heard me talk about this before. Earlier, we had a lunch with a lawyer where we talked about what is a guardian ad litem, and we talked about that only from the area of family law with minors. It's the same title, very similar sort of individual, similar sort of attorney. It's an attorney who goes through and does an investigation to look at what is in the best interest of their ward. The difference is their ward now is an adult. This changes the investigation. This changes the procedure a little bit. More importantly, when we talk about the guardian ad litem, this changes the training that that guardian ad litem has to go through. See, a lot of people don't realize this, but the guardian ad litem, by statute, has to get specialized training. And every time when we report, so for example, I actually have to report my continuing legal education or CLE credits this year, you have to report to the Supreme Court how many hours you've done for the various other forms of certifications that you get. So for example, I am a guardian ad litem for minors. I have to report how many GAL minor credits I take, and I have to keep my certification to stay a guardian ad litem. I have to keep a number of hours of that every 2 years. For adults, it's a slightly different certification. They have GAL adult credit hours as well, where you talk about process, you talk about continuing legal education or continuing legal issues that might come up for disabled adults that people need to be aware of. That is something that you have to certify and then get appointed from the court. Now, every county does this a little differently. Some counties keep a list of GALs and the court just appoints somebody. So in Brown County, which is where a lot of my practice is, that's what happens. I file, the court then says, okay, here's your guardian ad litem. And they have a list, they pick somebody out, and then you get that person. Other counties, it's not like that. Other counties, you have to call and then find a guardian ad litem on your own, and then that guardian ad litem gives assurance to the court that they have their hours taken care of. So if you're going to be hiring an attorney, make sure that they know the local practice in your county. If you aren't and you're going to do this yourself, God bless you. But make sure when you look to schedule a hearing that you ask the court what's the local practice, so you know if you have to go out and find a guardian ad litem or if you don't. A lot of times when I meet with clients, they always ask me the same question at this point. They say, why do I need a guardian ad litem? There are two basic answers to this question. A very cynical answer would be because the statutes say so, in which case the court has to appoint one. I think a better answer, though, is that a guardian ad litem is there to protect the interests of the adult. If you have an attorney just appointed for the person, that attorney is going to be duty bound to do what that person wants, whether it's truly in their best interest or not. If an individual truly is incapacitated, but they don't know it yet, they think they're fine, even though everybody else around them can see they're not fine. Well, that attorney can try the best they can, but at the end of the day, their duty of loyalty means they've got to make their client's case, whether that's the right call for their client or not. A guardian ad litem has a little bit more freedom to still look at the facts, but be able to say, I think this is what's going to be best for this person, which may or may not align with what that person wants. Having an independent attorney be able to do that is going to be very important. It's going to help these cases along. The next major question that you're going to have to look at as you're looking at whether a guardianship is going to be needed or can go or not is going to be the burden. What do I mean by this? Regular viewers will know you'll often hear me talk about what is the burden. This means what do you have to prove, how much evidence do you have to show. This is going to be a raised standard called clear and convincing evidence, otherwise known as the middle burden. This means you need to have more than just enough and not quite as much as something in a criminal court, which has you go really, really, really certain. This means you have to show something really important, really compelling. This is going to be done with a mixture of medical testimony, testimony of the family, and just other eyewitnesses. Again, it'll depend upon the facts of life that you see. These cases, they tend to be either very easy or very, very hard and painful. Typically, when you have an incompetent adult, you have a situation where everybody kind of knows that the individual is slipping away, but the individual might not. Or worse, half the family thinks the individual is fine and the other half thinks that they're not. And everybody's willing to go to court about it. Those cases get very hard, very sad, and get very, very intensive. If you go through and you have a guardianship put into place, that doesn't necessarily mean that the role of the guardian is done or that the interaction with the court is done. After you have the guardianship put in place, you're going to have the guardian is going to have a duty, particularly the guardian of the estate, is going to have the duty to put together something called an inventory. What is an inventory? An inventory is a listing of all of the assets that the ward, that is the individual who has been found incompetent and has the guardian appointed for them, that the ward has available to them that is going to be administered by the guardian with the power of the court. This usually needs to be done about 30 to 60 days after the guardianship is put into place. So the very first thing that a guardian of the estate is going to do is just start to get a sense out of what they have control over. This could be something rather simple, or this could be something rather complex. That's going to depend upon the situation that you have. Once the inventory is done, every year the guardian is also going to have to file an annual accounting. The guardian of the estate is going to have to file an annual accounting. There are two different accountings that can be done. One, a very simplified one for a married ward, typically where you have someone where they're going to have what's commonly referred to as an institutionalized spouse and a community spouse. So a spouse who is in the nursing home or a spouse who is has the guardianship and then you have a different spouse who is not. In that case, you could do a smaller accounting just because you don't necessarily want to, the court doesn't need to know all of the assets, just the marital property values and what's going on with that half, rather than doing a full accounting for both people. We still want to respect the rights of people that are not incompetent. If the person's not married, then you'll be doing a full accounting. Typically, what you'll do in this situation is you'll be listing off all of the assets from the previous accounting. You'll be listing off the income that's been brought in, the expenses that you've spent, and what the status is of all of the accounts. A guardian of the person will also need to file a report every year. This will be a report on the health of the board. What's their status? Where are they living? Has their health improved? Has it decreased? How often have you seen them? How often have you interacted with them? What sort of services are being changed? This is to give the court an update as to what you're doing for your duties as the guardian of the person. A guardian of the person has to make sure that the services are right, that the individual is getting the treatment that they need, that their health is at least staying the same, or if it's declining, that there's something being done about it, if there is anything that can be done. These are the sorts of situations that you have. One of the more interesting things that I have is when we have a situation with a young person who needs to have a guardianship. Typically, you have someone who is developmentally disabled from a very young age. They cannot function as an adult. They're always going to stay at about a 7-year-old, a 5-year-old, a 4-year-old level. When working with the parents of these special needs individuals, one thing I often come across is a notion that their child is still going to be their child. This is really understandable. After all, they know probably better than anybody else that this child is going to stay a child basically for the rest of their lives. The problem is the law doesn't see the individual as a child. They've reached the age of majority. They turned 18. They became an adult. This means we need to put a guardianship into place, in which case they're treated as an incompetent adult, which is slightly different than a child. This means we're taking rights away. This means that there may not be the same sorts of underlying custody and placement decisions that we have built for children that we don't necessarily have built for incompetent adults. Normally we think of there being one guardian of the person rather than two who may or may not be divorced. This sort of language difference can lead to problems if you're not aware of this, if you don't plan for this, if you don't have specific things put in place. The other interesting thing is a question of, do we always need a guardian of the person and a guardian of the estate? The answer is no. This is going to be very fact specific. If you have somebody who has been developmentally delayed and they've been essentially handicapped from a very small age, they probably will not have money. And so at that point, as long as you've done the right planning, they won't have money when they're very young, they won't have money when they turn 18, and they will probably never have money because you've always made sure that person is at that $2,000 limit so that they can keep their benefits, they can keep their health insurance, and you know they're never going to have a job, they're never going to buy things that are going to be super expensive. They don't want that. A guardian of the estate isn't really necessary in that point. Instead, you'll probably work with the Social Security Administration and become somebody's what's called rep payee, meaning the Social Security Administration will pay a certain individual the money to manage it for the disabled individual. In this case, there really isn't a guardian of the estate needed, but there absolutely is the need for a guardian of the person. The opposite could be true too. You could have an individual who just can't spend their money. Technically, one of the standards that you could prove by clear and convincing evidence is that an individual is a spendthrift. They're completely fine mentally. They don't have any developmental disorder, but they just get money and they spend it to a point that is highly dangerous to them. Not common, but possible. In which case, you could just put in a guardian of the estate, and then you have a separate individual manage their business affairs because this individual can't. The last thing I want to touch on today is going to be the notion of a conservator. This is something a little more uncommon in the state of Wisconsin. A conservator is a voluntary action where an individual will go to the court and say, I want so and so to help me manage my money. In return, they're not found incompetent as they would be with a guardian of the estate, but that person still has all of the powers and functions and duties of a guardian of the estate. This sort of hybrid action can allow for a solution in very particular situations, particularly where you might have somebody who is very much trying to defend against a guardianship action, and you might have some people, some family members, or even adult protection services wanting to say you're a spendthrift or you're incompetent now, and they're very much concerned with financial abuse by certain individuals. You might find a compromise point where you can find somebody else that is trusted by everyone to step in and voluntarily take that. That way, the ward or the potential ward can retain dignity, can retain their competence, and not be determined that by a court, but still be able to have the assistance that's needed to give assurances to everyone involved that there will be situations taken care of. If you have a situation where someone is in your life is starting to slip, you're very concerned about this, it is time to talk to an attorney. And if you have questions, please feel free to give us a call at Peterson Burke and Cross. We'd be happy to sit down and talk with you, talk through potential solutions that could allow you to preserve the dignity of the people you love while still being able to offer them protection. Give us a call, 920-831-0300, because at Peterson Burke and Cross, we specialize in you.